MPs and MLAs have parliamentary privileges which protect them from criminal prosecution. This privilege provides like an immunity to the MPs and MLAs. But will they have this immunity if they are taking bribe to cast a vote for a particular person? To your surprise, they had the immunity from being prosecuted if they take bribe because Article 105 Clause 2 protects a member of the parliament against proceedings in the court that related to or concerns or have a connection or nexus with anything said or vote given by him in the parliament. Now, the question of immunity against bribe to a member of the parliament was raised again in a recent hearing of the Supreme Court, where a 7-judge bench was constituted to hear the matter. And in this particular case, this time, the Supreme Court ruled that members of parliament and members of legislative assemblies can no longer claim immunity from prosecution for accepting bribes related to votes or speeches in legislature. The court held that bribery is not a protected parliamentary privilege. Now, this judgment overturns the ruling in P.V. Narasimha Rao's case in 1998. But what was the judgment in the P.V. Narasimha Rao's case? Let me tell you all about this case. In 1991, the Congress-led party formed a minority government with 232 seats, below the majority rank of 272 in the loksabha. Now, in July 1993, a no-confidence motion was introduced by the opposition party, and the Congress had 251 votes, falling short of the majority. Despite this, the government survived the vote by a 14-vote margin. A year later, the CBI registered a case on allegations which surfaced that 6 Jharkhand Mukti Morcha MPs, including Shibu Sorin, took bribes to support the government. This raised concerns about the political landscape and ethical conduct within the parliament. But the Supreme Court quashed the case, which led to the setup of a 5-judge bench in the Supreme Court. In 1998, the court ruled that MPs and MLAs are granted immunity from criminal prosecution for taking bribes to make a speech or vote in the legislature. It held that parliamentarians have immunity against criminal prosecution for any speech made and vote cast inside the House under Article 105 Clause 2 and Article 194 Clause 2 of the Constitution. Now, fast forward to 2012. This immunity was challenged in a recent case involving Sita Sorin, who is a member of the Jharkhand Mukti Morcha and also the daughter-in-law to the former Chief Minister Shibu Sorin. Now, Sita Sorin was accused of accepting a bribe to cast a vote in favor of a certain candidate in the Rajyasabha elections of 2012. Soon after, the CBI filed a charge sheet against her. In 2014, the Jharkhand High Court dismissed appeal, and that dismissal was in turn appealed in the Supreme Court. In her plea, she had claimed that she enjoyed legal immunity under Article 194, Clause 2. In September 2014, a 2-judge bench referred the matter to a 3-judge bench. And in March 2019, the 3-judge bench, headed by CJI Rajan Gogoi, noted that the decision in P.V. Narasimha Rao's dealt directly with the case, considering that the case had been decided by a narrow margin in a 3:2 majority. It was then referred to a larger bench, underscoring that the issue was substantial and of general public importance. Eventually, in September 2023, a 5-judge bench headed by CJI Chandrachud doubted the correctness of the majority view in P.V. Narasimha Rao's judgment and accordingly referred the matter to a 7-judge bench. Now, let's discuss the key events of this recent case as well as the standing of the court. The Supreme Court, led by Chief Justice D.Y. Chandrachud, considered the gravity of the P.V. Narasimha Rao's judgment and its impact on public interest, probity, and parliamentary democracy. The court emphasized that the purpose of Article 105 and Article 194 is to facilitate debate and deliberation within the legislature, which is compromised if bribery influences a member's vote or speech. The court clarified that bribery is not immune under these articles because it involves criminal acts unrelated to essential functions of voting or speaking in the legislature, and it is non-essential to the way a vote is being cast or a speech is being made. The court also affirmed that the offense of bribery is complete when the legislature accepts bribe regardless of the subsequent actions like voting or making a speech. I hope you've understand this judgment and the history of the judgment. For more such judgments or information like this, kindly subscribe to India Legal.